Hello, I am Sister Anissa, and I would like to talk to you about republicanism. As you commemorate the day that your nation, Trinidad and Tobago, became a republic, I want to remind you that republicanism is a philosophy of governance which emphasizes the protection of the inalienable and inviolable rights and freedoms of all people. When we say that your rights and freedoms are inalienable, we mean that these rights and freedoms do not come from man. They do not come from the legislative pen. They do not come from a majority, but they come from the Creator, God. You were born with them. They are yours, cannot be separated from your humanity. And as such, they are inviolable or ought not to be violated. This is what we mean when we say that the rights and freedoms of the people are inalienable and inviolable. It is therefore for this reason that governments are instituted among men to protect the inalienable and inviolable rights and freedoms of all the people. As a result of this, constitutions around the world which are republican or have been influenced by the philosophy of republicanism all have a section known in some places as the Bill of Rights and in some as the Fundamental Rights and Freedoms section, an area in the Constitution which outlines the inalienable and inviolable rights and freedoms of all people. And such constitutions also have limits on government power and authority in the face of these inalienable rights and freedoms of all of the people. So when you celebrate Republic Day, you need to realize that it is not only about being independent from Britain or from a monarchy, but it is about the celebration of your God-given or inalienable and inviolable rights and freedoms. It is very important, therefore, for your society to cherish these inalienable rights and freedoms and to ensure you remain vigilant about government's power and behavior while in office to ensure that they do not pass laws which infringe upon those inalienable rights and freedoms, thereby preserving and protecting your republic. You must therefore watch out for the kind of legislations that are being passed in your parliament, for the kinds of legislations that are being proposed by your government's policies. Because whenever governments begin to pass laws which have the potential and the tendency to infringe upon your inalienable rights and freedoms, then that is a threat to your republic. Yes, my dear people. In the region and around the world, we have to be very careful about this. In the great United States of America, which also is a republic, we have seen that the rights and freedoms of the people are disappearing. Religious liberty is under threat. Freedom of expression is threatened by things like hate crime and hate speech laws. Laws forbidding criticism of certain immoral behaviors like sodomy or homosexuality are being passed in the United States and in other nations of the world, which infringe upon the legitimate freedom of speech and freedom of conscience of Christians, for example. Even right here in the Caribbean, we have to be very careful. On the 21st of August 2013, in the House of Senate in the Spice Island of Grenada, our neighbor, Caribbean neighbor, the government passed a bill, which is now an act, called the Electronic Crimes Bill 2013. This law has certain provisions in it which infringe or have the potential to infringe upon the freedom of conscience, freedom of opinion, freedom of expression of the people of Grenada and also of persons who enter into their jurisdiction. It is an electronic crimes bill or law, and therefore it affects communication which is sent via the electronic media, using email, for example, using social media, Facebook, Twitter, and other social media programs and blogs. I want to highlight for you certain areas of that bill, law, which are very dangerous to the rights and freedoms of the people. And I want you to take note that this is happening in our Caribbean neighbor island of Grenada. In the Electronic Crimes Bill, the two sections that are of concern and danger to the exercise of the freedom of expression of Grenadians and other persons are Section 6 and Section 16. Yes, my dear people. Section 6 deals with sending offensive messages through communication services, etc. And Section 16 deals with what they call electronic stalking. In brief, Section 6 forbids you from knowingly sending information via an electronic system which is grossly offensive. And if you were to do so, that is, send such information which is grossly offensive, you can be fined up to 100,000 EC dollars or sent to prison for up to 1 year or both. It also puts that penalty upon a person who would send an electronic mail or an email or an electronic message, and I quote, for the purpose of causing annoyance or inconvenience, etc. The problem with this section is that it does not tell you how to interpret what is grossly offensive. It does not tell you how to interpret what causes annoyance or inconvenience. These terms, which are subjective and are dependent on the personal feelings of the individuals who claim to be annoyed or who claim to be inconvenienced or who claim to be grossly offended, these terms being so subjective and not having legal certainty are sure to cause problems for Grenadians and other persons. The law is essentially making it an offense to send information via the internet which causes a person offense, which causes a person annoyance, which causes a person inconvenience, and none of those terms are explained. So ultimately, it would be left up to the arbitrary feelings of a judge in a court of law to decide if your communication through the internet was annoying, inconvenient, or grossly offensive. Section 16 does a similar thing. In Section 16, which deals with electronic stalking, this is what it says, and I quote, a person shall not knowingly or without lawful excuse or justification intimidate, coerce, insult, or annoy another person using an electronic system. And what is the penalty? A person who contravenes subsection 1 commits an offense and is liable on summary conviction to a fine not exceeding $100,000, that's EC dollars, or to a term of imprisonment not exceeding 3 years or both. So here we have a section in the Grenada Electronic Crimes Act of 2013, passed on the 21st of August, which criminalizes the act of sending information via the internet which can intimidate a person, insult them, or annoy them. But who determines what kind of information annoys? Who determines what kind of information insults? Who determines what kind of information intimidates? Even the truth can be insulting to a person. Even the communication of the truth through the internet can be seen as annoying to another person. Even the communication of the truth through the internet can be seen as intimidating or causing inconvenience or causing annoyance or grossly offensive to another person. Is this law going to criminalize you because you speak the truth and someone is annoyed? Is this law going to penalize you with a fine of up to $100,000 because you speak the truth and someone is offended? Is this law going to send you to jail because you speak the truth and someone feels intimidated? Is this law going to send you to jail because you speak the truth and someone is inconvenienced and annoyed? My dear people, this ought not to be so. This is not the purpose of government legislation, nor is it the role of government. For as we have shown you, republicanism and the principles thereof teach us that the rights and freedoms of the people come from God, they are inalienable, and the only role of government is to protect those rights and freedoms. This law interferes with the freedom of expression, which is inalienable, of the people, because it interferes with the communication of your expression through the internet by criminalizing communication which another person by their own subjective feelings may deem to insult, annoy, be inconvenient, cause him or her annoyance, and be grossly offensive to him or her. We have to be concerned with this electronic crimes bill and these sections that have been passed in Grenada. These particular sections ought not to be. My dear people, in order to ensure that the laws of our countries do not transgress the principles of good governance, which republicanism upholds as a philosophy of governance, we must ensure that these laws are certain. The laws must be certain, they must be clear, precise, and they must guarantee the rule of law. Legal certainty is important for the guaranteeing of the rule of law. When we look at the Grenada Electronic Crimes Bill, we see that it criminalizes communication sent via the internet, which a person may deem grossly offensive, which a person may deem to insult, to annoy, or cause annoyance and cause inconvenience. Yet, as we have shown, these things are all subjective to the person in question who may feel annoyed, insulted, inconvenienced, or grossly offended. This creates a scenario that would not encourage another principle of good governance in republicanism, which is equality before the law, or being equal under the law. Why do I say this? Let us take a practical scenario. If you send information to another person via the internet, and that person feels grossly offended by what you have sent and decides to bring a claim against you under this Electronic Crimes Act of 2013 of Grenada, and in the judge's own personal opinion, since he has no guidance in the law itself to determine what is grossly offensive, in his own personal arbitrary judgment, he decides that the information you sent electronically is in fact grossly offended and you ought to be charged, you would be guilty of having committed a crime. On the other hand, if somebody sends the same information that you sent to another person, but when the person sees the information, he or she ignores it because they said, well, I could tolerate that even though I don't agree with it, that person goes free. Because the individual who ignored the information they sent decided not to take a claim before the court against them under the law. So some people will go free and some will be caught under the law. Therefore, there's no equality before the law. This is very bad for the upholding of inalienable rights and freedoms in our countries. But this is what is happening in Grenada right now under the passage of the Grenada's Electronic Crimes Act of 2013. Furthermore, my dear people, we have to consider what such legislation, that of criminalizing offense, insult, annoyance, inconvenience, and criminalizing things that intimidate, even though it may be the truth that you are speaking, that kind of legislation would lead to an immature society, because it would mean persons would be encouraged to engage the courts every time they feel offended. It will be a waste of the court's time and resources. It would cause fear to be instilled in persons, because they would now be afraid to publish their comments and their opinions on Facebook and other social media where they use the internet, because of fear that they could be fined or even go to prison under the Electronic Crimes Bill for simply speaking their opinions, which someone else may find offensive, insulting, annoying, or causing inconvenience. So it would create fear and could lead to people censoring themselves or self-censorship. This would hurt free expression in a society, and it would remove the necessary exercise of criticism, which is important to allow new and better ideas to arise to help with the development of a nation. Therefore, such laws are anti-rights and anti-freedoms. They are against the inalienable and inviolable rights and freedoms of the people, their freedom of expression in particular. They are against freedom of opinion and freedom to communicate that opinion without interference. And they are ludicrous and very vexing and very disturbing and very backward, not progressive at all for any society. Let me ask Grenada this question. If a resident in Grenada were to say to the government, well, I find this Electronic Crimes Act of 2013, which you have published on the internet, to be grossly offensive to me, because I have rights and freedoms which are inalienable, and this act threatens to take away my legitimate rights and freedoms. I find it annoying, I find it offensive, it insults my intelligence as a Grenadian. Can he or she bring a claim against the government? This just goes to show you how ludicrous this piece of legislation, these portions of it, are. And if the Grenada government is truly interested in the protection of the inalienable and inviolable rights and freedoms of its people, then it ought by right to repeal those sections of the law that it just passed, amend it by repealing Section 6 and Section 16, the bad parts thereof. We want you to understand these things in Trinidad and Tobago, because this law, interestingly, does not only apply to Grenadians. Yes, my dear people, the application scope of this piece of legislation will have impact upon other persons who are traveling through Grenada for one purpose or the other, including persons like you, Trinidadians, or me, Vincentians. In the application section of the Act, Section 3, it tells us plainly that the Act applies, and I am quoting to you, this Act applies where an offense under this Act was committed in Grenada, that's Part A. Then in Part C it says, an offense under this Act was committed by a Grenadian national or a person resident or carrying out business in Grenada or visiting Grenada or staying in transit in Grenada. End of quote. In other words, you could merely be passing through, staying in transit, you're on your computer or your iPad, you're using it and you're blogging, sending messages, publishing your opinions, and if there is anything in your published electronically statements which someone in Grenada finds offensive or insulting or causing annoyance or inconvenience to them, that person can bring a claim under this law in the court against you, even though you are just a Trinidadian passing through in transit in Grenada. Can you imagine that? Yes, my dear people, these are the facts. I took the time to explain this law and these notorious sections thereof, which are anti-rights and anti-freedoms and are not in the interest of the protection of the inalienable rights and freedoms of the people, which is what republicanism is all about. I took the time to explain it to you because you need to understand this is how republicanism can be attacked in a country, through bad legislation which infringes upon the rights and freedoms that are inalienable and inviolable. Therefore, beware, be watchful, call upon your government to condemn these anti-rights and anti-freedom sections of the Grenada Electronic Crimes Act 2013, and you be watchful of your own country and government and the laws it passes, because if you want to preserve your republic, if you want to preserve your inalienable rights and freedoms under God, under your constitution, you must ensure that the laws that are passed to govern you are not laws which attack, infringe upon your God-given rights and freedoms. May God bless you. Happy Republic. Remember, know your rights, cherish them, guard them, defend them, assert them, and exercise them under God with respect for the rights and freedoms of your fellow men.